Welcome, everyone. My name is Bobbi Brandt. I'm the president of South Central Wisconsin MLS. I am joined with Tom Weber, past president of South Central MLS and the Realtors Association of South Central Wisconsin, teamed up with the MLS, and we wanted to bring to you today very impressive Matthew Marx. He is the co-founder of Evocalize, and we wanted to bring him on to talk about a new issue that will affect some of us, not to terrify us, but to make us aware of what is coming, what's in the pipeline coming up on January 27th of this year. So, Matthew, I'm going to let you introduce yourself and tell us a little bit about your company and your expertise in TCPA, which is the Telephone Consumer Protection Act.
Sounds good, Bobbi. Well, thanks for having me on, Tom. I appreciate the time. And yeah, I mean, if we don't have enough to worry about out there, we're going to introduce one more thing, perhaps, but we'll hopefully give you some guidance so it's not as mysterious as it was and before this. And the goal is just to get education out there. So you know, and so just a little bit about me, Bobbi, so everyone knows a little bit about who I am. I'm the co-founder and CEO of Evocalize. Evocalize, for about the past 10 years, has run some of the largest lead generation programs using data, automation, and AI in the real estate industry, now the mortgage industry as well. We serve and built our technology actually with many of the portals for them to generate their own leads. And in many cases, they then bundle them up and kind of distribute them or sell them to these industries in different ways. And then we just a few years ago opened that up to brokerages and tech platforms. Many of them in the real estate space now have embedded our lead generation engine underneath their technology that they have today. And then we have something pretty exciting coming in the next few months in the real estate space where we're going to basically release for the first time this technology direct to teams and agents. We've already done so with loan officers in the mortgage space, and we're having a lot of success. So a little bit about us. In terms of TCPA, so maybe I'll give a little background, Bobbi, of the law and what's changing and why it's changing, so people understand kind of the intent, which maybe will help them get their hands around it, and then we can roll into some more advanced and unpeel the onion, if you will, from there. Does that make sense from a talking point perspective?
That sounds great. Thank you.
Awesome, sure thing. So just a little bit about the law the background to the law before we get into what's changing. By the way, to keep your attention, this is something that will affect everyone. It starting in just a couple weeks on January 27th. There are going to be some big changes, and the attorneys involved most industry players expect this to impact our industries, the housing industry, as much or more than the Sitzer-Burnett lawsuits. So in terms of economic impact and disruption. So to keep your attention as we've set the stage, this is a really important thing. Like you need to know about it.
Another big thing. Yeah.
Another big, I'm sorry. I know there are a lot of big things.
I'm not just interested, I'm terrified now.
Right.
I know. Right. I'm sorry. We'll make it easier. Education is the biggest remedy, right? I had an accounting professor in graduate school that said forewarned is forearmed. And it took me a while to understand it, but that to me is what we're trying to do here. So, okay. So the TCPA, the federal in the United States, this is the United States law, right? So if you're in Canada, if you're in Mexico, if you're around the world, we serve a global audience at Evocalize. This doesn't apply to you if you happen upon this recording. But for our core audience who we're talking to within the MLS, this is going to affect the FCC, Federal Communications Commission, oversees a series of laws called the Telephone Consumer Protection Act. Now, this Protection Act was originally passed back in 1991, and it was based on a bunch of laws that came all the way starting back in the 1920s. But 1991 is really when it was codified. And the reason for this law that was put into place was because for those of you who are around, I have the gray hair to prove it, there are phones attached to the wall of every house back then, right? And so it had a big cord, and you'd walk around, kind of with a long cord. Well, that phone started ringing and ringing and ringing to all these houses. And so people started getting frustrated. The phone was ringing at all hours. And it happened to be that marketers learned that they could call your house and get your attention because there was no caller ID back then. You didn't know who was calling. So you had to answer the phone every time. And so that's really like the basis for the law comes all the way back from that time. It was to try and prevent marketers from abusing this, like calling you and reaching out to you at all hours. So we had some iterations of the law over the years. 1991 was a long time ago. And, do not call list. We have some other things that came up that you should be familiar with. If you're not, please become familiar with it. They're serious things too. And then if you fast forward to about 2 years ago, the FCC just had so many complaints from folks. Now that we're carrying this in our pockets around with us every day, marketers saw another opportunity, right? So they're like, hey, we can ring someone not just at their house, we can ring someone everywhere they are. And not only can we ring someone, we can text them. And so this, probably everyone listening to this has heard, I certainly experience it daily. It's hard for me to even answer the phone because it's often someone trying to sell me something that I haven't asked for. And I'm on the do not call list. I'm on other things. It doesn't matter. They still call and they text. And so the existing laws effectively weren't kind of satisfying what the government thought that they needed to satisfy to protect against this spam. And so 2 years ago, the FCC formed a working group that went and investigated the changes that they could make, the reasoning behind the spam, because there was already a do not call list, right? So they thought, why is that not working? Why is that not sufficient? Well, it turns out that it wasn't. And the working group discovered a number of things. Some of them we won't cover in detail in this call because they're not as relevant to you. For instance, they empowered and required the telecom companies, the AT&Ts and T-Mobiles and Verizons, to lock things down a little tighter, certainly from international calls and some other things, right? So there's some laws that aren't directly related but will impact this problem. And then there's some things that are very close to the vest. So in November of 2023, so a little over a year ago, this working group passed an order. And the order is it's like an interpretation of the law. So they didn't actually put this through Congress. This isn't a new law that's coming out. This is an interpretation or order of clarification on the existing TCPA law. The order did a few things, but there's one thing that's really important to y'all. And they passed it in December of 2023, and it goes into effect after a little bit of delay on January 27th of this year, 2025. So just a couple weeks from now. And that is they're attempting to close the lead generator loophole. I'm going to explain what I mean by that in a minute. And they're requiring what they call one-to-one consent for leads in order to do certain things with them. And so let me explain that. I'm going to unpack that a little bit. Before they do that, I want to make sure I'm on track. Bobbi, Tom, we feeling good about this? Anything that I should clarify before we go to the next step and talk about what one-to-one consent is and how we roll with that?
I think those key changes would be great.
Yeah. Yep.
Awesome. Okay. So cool. So a little bit of background on the law. Now we know the date that it's coming in and going to be enforced. The intent of this was to close the lead generator or lead aggregator loophole. And this simply means that this working group figured out that one of the problems that was causing a lot of spam was the portals and marketplaces, all the rate comparison websites, they classify them as lead aggregators or lead generators. And what they were doing, the way this business model has evolved and works, they go out and do a bunch of marketing. So they market to potential home buyers and sellers on Meta and on Google and lots of other places online. They get them and they do it over time. They're very consistent and good at being consistent. And they get folks down onto their websites where they learn more about them and get them to eventually fill out a lead form, right? And so they get them to fill out their name and email and phone number on the lead form. And historically, that's all they had to do. They got them to fill out the lead form and then they decided who to sell it to, right? And so they would take that lead and they would monetize it, which means sell it to lots of people, right? And so They learned over time, if you're any business, if you could take a house and you could take that one house you got a listing contract on and you could sell it to like 5 families and, you know, they didn't have to live together, you would do that all day long because your commission will go up, right? GCI will go through the roof. That's what these lead generators realized. So they started out just selling, if they got a mortgage rate or a real estate, someone who's interested in a listing, they would just sell it to 1 or 2 or 3 people. They realized over the past 5, 6, 8 years that they could make $20, $50, $100 every time they sold that lead, and lots of people wanted it. So they started selling it to more and more people. So what that caused was a rush on, and we call it speed to lead in the industry, right? If you've heard that, everyone maybe has heard that terminology, speed to lead. Speed to lead is really important today, and it's measured in seconds because you're fighting for attention to that lead to everyone else, with everyone else who's also engaged with that consumer and in this case, purchased that lead. And so what happened is that causes a rush of spam. So when you've submitted an online lead through one of these portals, often you'll get like flooded with calls immediately in text. And so this one-to-one consent specifically is geared to stop that or to limit it. Okay, so here's what the new rule requires. This is specifically related not to email, to telephone calls. It governs your phone number, right? So the TCPA specifically governs telephone calls and texts using any kind of technology. They call it regulated technology, but any kind of technology to like auto-populate a phone number or auto dial or using any kind of voice or anything related to that. So if you pick up, this is not relevant, what I'm about to say is not relevant if you pick up the phone and you call someone one-to-one. If you the human, call someone and they've submitted a lead to you, you can call them without going through and worrying as much about what I'm about to say, okay? So keep that in mind with everything I'm talking about. Instead of now in the future world, one-to-one consent means a consumer, when they submit a lead, before they submit the lead, they have to specify exactly who they want to contact them via a checkbox, right? And so instead of being able to submit the lead and then without any kind of consent form or anything, and then have after the fact, someone then decide who calls them or have that in fine print on a, separate website no one can find, that has to be clear and conspicuous. So the FCC has said specifically, you need to present the consumer with empty checkboxes that when they come in to submit a lead, they have to go, okay, I want to send it to Tom or to Bobbi or to, right? I want to send it to the service provider that's going to fulfill and call me. And if anyone calls me that's not one of those service providers, they're not allowed to call, right? They're not allowed to even get the lead to be able to call. And so that's what I talk about, the one-to-one consent means. If I do marketing and I get one person to come in, that one person has to consent by checking a box, an empty checkbox. The laws even said you really can't even pre-fill the boxes. There's a little like gray area there, but literally empty checkboxes. I want to check to have exactly who I want to call me or text me be present on the form. And if you're not present on the form, you're not supposed to be able to use that lead for any kind of technology underpinning it in order to call. And this is intended to shrink the number of calls and have just folks that the consumer wants to call them at the end of the day, if that makes sense.
Wow, is that going to be a change? So
That's a lot.
if I'm hearing this right, and I don't want to use it, I'll just say portals. So if I'm an agent buying leads from a portal, I've got to make sure they've actually done this. They haven't pre-checked a box, and we all do that, right? Like a license, like, yeah, I agree. We never read it. So they can't do that anymore. They literally are going to have to say, the consumer is going to have to say, I'm willing to allow this person to contact me. So the confusion over maybe sometimes portal leads coming from speed to lead, 8 agents trying to call them, none of them being maybe the listing agent.
Right.
Now the consumer is going to be, if I'm tracking this right, Matt, they're going to maybe get a list of 8 possibilities to call them. And if they don't check there is no lead. And now I'm going to need to hang on to that data somehow?
I
Do
have
I
a
have to
question.
receive it?
I have a question about that though. If the agent is calling that lead directly, are you exempt from having that anything for TCPA signed, a consent signed?
Yeah. So one thing I forget to say always to cover y'all too, talk with your
I'm waiting for
attorneys. So Tom, I told
We're
you
not
I'd say this,
attorneys.
right? So we're trying to bring this really complicated thing to you and let you understand it. If you have any concern or question, please talk with your own counsel, your broker's counsel, and clarification. Because Bobbi's not your attorney and Tom's not your attorney and I'm not your attorney, but just sorry, we have to do, have to do that
Thank
whole
you,
thing.
Matt.
My attorneys make me do that too. Okay, so but Bobbi, you're totally 100% right. That's exactly right.
So what we have to be concerned about are auto dialers, mass text messages, things of that nature. And so if we can dig into that a little bit deeper, as far as, all right, if the lead does come from a portal, if the client has signed consent with the portal, is the brokerage and the agent then protected through the consent of the portal?
This is a great topic. I'm so glad you brought this up. Okay, so one of the interesting nuances of this order is that it defines who needs to be consented, and the consent is defined as they call it a service provider, and so consent needs to be at the service provider level. Let me explain what, and then an agent in this world is considered, a realtor is considered a salesperson. Remember, this law is not specific to real estate. It's not specific to housing. This is for everything, right? So insurance is having to deal with it, and every healthcare, everyone who deals with leads, right? So this terminology is a little goofy in this industry because, we as realtors don't necessarily think of ourselves as salespeople, right? We're a lot more than that, right? But so the service provider, Bobbi, is typically the representative brokerage that you fall under, whoever holds the license that you're underneath as a particular agent. And so the consent that you have has to be named. And again, we serve many portals, right? So we've had to re-engineer a lot of these lead generation products to populate the brokerage name, the representative brokerage name in the lead consent forms that are being kind of checked as a consumer comes down and fulfills the lead. So that the lead consent form that you get in the proof of lead needs to be the service provider, and in almost all cases we've seen in real estate, that is the brokerage, not the agent themselves. It's the representative brokerage that holds the license, and that's because the service is considered the buy or sell of the home in real estate, not the consulting, right, or the selling action of choosing a home, right, or helping to sell a home. It's now this will be litigated out, so there may be, as we get along, there are lawsuits associated with it. You just don't want to be one of the lawsuits that litigates this out, right? But like they'll figure it out. So it may be that they adjust this thing going forward, or the lawsuits determine that you can put your own name over time. We don't know that yet. So the most conservative way to do this is you need proof. No matter, we're telling people, no matter where you get the lead from, it needs to come with proof. And the proof needs to be a consent form that says, consumer consents to, and it needs to have them check the box. Consumer consents to being contacted, and that contact might include, to cover yourself fully, might include automated dialers, automated technology, and I would encourage folks to include AI and pre-recorded voice in that disclosure as well. But every lead you get, if you don't get that, you're taking a risk, right? So all of this is like, we don't want to stop people from doing business, right? But realize that all of this is a risk tolerance. So you need, as a professional, to decide how much risk you want to take. I will say, we all expect there are attorneys waiting, class action attorneys waiting to dial phones to try and trap people into these lawsuits starting January 27th. So there's going to be there's no way around it. There's going to be a flood of these lawsuits that come out starting then. And I would encourage you to not be one of the first. So you want to really protect yourself. And service provider, no matter where you get a lead, if you generate the lead yourself, you should have a disclosure form that says who the representative brokerage is as your service provider as well. So yes, I went a little bit farther, Bobbi, but yes, any lead you get, got to have that.
And so companies with a chatbot on their website, as soon as the consumer starts to engage with the chatbot, is that when you suggest that, I know you're not an attorney, but is that when you're suggesting to have that consent form pop up?
Before you, in the process of capturing the lead. So regardless of where it's happening, if you're capturing the lead, again, unless you specifically are only ever for the life cycle of that lead going to manually call them, if you're going to use any technology in the course of dealing with that lead, which I would just argue is if you say, you know what, I'm not going to do this because I'm just going to call everyone manually, just be really careful with that, because then you have to classify and tag your leads and understand what you can do with what lead. So, but yes, anytime you're capturing anyone's identity information, personally identifiable information is what the industry calls it, their name, phone number, you need to be getting their consent and capturing that consent along with the record of the lead itself.
Okay.
Oh boy. So I'm a little thick. I'm going to see if I can boil some of this down and see if I'm tracking that. So I'm an agent and I'm using one of the name, there's a bunch of them out there, the latest CRMs, which probably a bunch of them are your clients. So I'm not going to have you pick one.
Yeah.
I'm
going to avoid it anyway.
So I'm using that CRM. Now, I'm not in a call center. I'm not dialing 5 numbers and see who picks up first and talk to them and the junk I get on my cell phone right now. I'm just using the auto dialer in there to just make life easy, to just dial my phone to call one person. And from what I'm hearing, the minute I use the auto dial function, most conservatively, I might be in trouble.
Yes. And the liability, these things add up fast, right? So you're talking about depending on the circumstance, between $500 and $2,000 per call is kind of the risk that you're taking here, right? And that's not even thinking about the third party lawsuits that are gonna pop up in class action. So yes, and Tom, and I know you know this, but I'm going to say it anyway to make sure that everyone hears it. This law, it's a little confusing how it's written. It is retroactive. So your existing database that you're sitting there and already using in your CRM and already doing an auto dial and already doing a auto text, just because you're doing the right thing, like you're a good marketer, right? As a realtor. And you're farming, your database, right? You're doing the right things. You're doing everything we've always said to do.
Yep.
If you do that starting January 27th with leads that don't have this new consent, one-to-one consent that you can prove, you are exposed to the risk for violation of this law. So it's not just the new lead you capture. It's the existing lead that you have in your database. And there are all kinds of nuances around prior business relationship. I would throw all those out. Don't even think about them, because it's really in what's informational and what's marketing. Because in talking with the attorneys, and I've done lots of podcasts with the leading attorneys, top to bottom, I've been on Capitol Hill talking about this in the last year. There's so much nuance in each one of these little caveats or exceptions. It's too complicated for anyone to understand, right? And so what we're advising people to do is think of every bit of outreach as marketing outreach, because even informational, there's a little bit of an exception for informational outreach in some of these laws. But even if there's anything in there that's even in language that's anywhere close to marketing, you're exposed. So I would, if anyone tells you, nah, it's not a big issue because it's not marketing related, be very skeptical. I would advise you, because this is it's your existing contact database. Any new leads you develop, you need to have proof of consent. one-to-one consent to be able to use any kind of auto dialer, to your point, Tom, in your CRM or auto texter, anything like that, anything more than you picking up the phone and ring, 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 dialing people one-to-one, you need to have that consent for.
Okay, so now I'm having a heart palpitations again, Matt. So I've
Sorry.
got lots of different words described. I've got an action plan for my past consumers that I've worked with and my past thrilled customers. And maybe for the next 10 years, I might be touching them by email. I might have a reminder for me to give them a phone call. What you're telling me is, even though they're not a new lead coming in, if I'm going to use my dialing service in the CRM, or I'm going to turn on maybe a conversation starter type text to just, hey, I'm still here, you guys, and let's connect. I have to go back and get from my past people that have already
Yes.
consented and been receiving stuff and not complaining. If I want to be safe, I got to go get a consent form from them.
100%. Yep. And
Oh my
there are lots of agents, I shouldn't say lots of, because the percentages are very small who even like understand this yet, but there are agents who are proactive, who are going out and using auto dialers and auto texters to reconsent folks now before the law
it's
goes
illegal.
27th.
because what
smart.
people right
Yeah.
because come January 27th, you're
Yeah.
breaking you're breaking the rule. You're violating the rule if you use technology to get folks to consent, right? So you starting January 27th, you can't use any technology to get people to consent via text and phone. Again, you can always email. You can email.
So
Yes.
email is exempt. So when we talk about marketing, we can continue to market our listings through email. Under TCPA, we're good.
That's right. TCPA doesn't cover an email. It just governs. There are a few other small minor things that govern email, but you already generally know about them. You're probably already doing them. The telephone and text, calls and texts is
anything that hits the consumer's phone.
That's right.
Potentially.
So if I have a great new listing, I'm going to individually text, 3 people that I know that might be interested. I send them a text, great, done. The second that I change that to a mass text about this great new listing through automation, all bets are off.
Yeah, and even it gets so far as even if you like pre-populate messaging in your manual text, like there's, the question is out there and it hasn't been legislated out yet. Like if there's AI, like Apple Intelligence is on every iPhone now, and it's like offering to write things for you. If you use that, you could be violating this law just by pre-populating the data and the text that you write, even when it's a one-to-one text. So that's where we have to be, especially, I think personally, those are going to be harder to enforce and figure out. Like if, again, on a personal risk tolerance, if I'm out there in the field, this is just my own, personal belief, but I have less concern about that than I do if I'm using an automated dialer or an automated texter to text 3 or 4 or 5 or 10 or 50 folks about it.
Within your consent form, do you need to have two different checkboxes, like yes, I agree to be contacted by phone, yeah, or no, I don't agree to be contacted by text? Is there differentiation there?
So again, we've pre-wired. I kind of feel strongly that like as much as we can, the tech providers in the industry should be helping with this and trying to understand it enough to protect people proactively. So what we've done with our partners, with some of the portals like our partner and investor realtor.com, we worked with them to wire up where we're involved through technology, wire up their consent forms. There are some of our partners, some of the largest brokerages that run our technology that are very conservative. They don't have separate text boxes for text and phone, but they do have 2 text boxes for different kind of, one for AI, artificial technology, and one to consent to be contacted about the listing. But that's rare. I would say the most common is one single checkbox. You don't have to have a yes or no, just a checkbox. And then there are some folks, and we pretty sure it's compliant. It's compliant with how the attorneys read the law, but It's not exactly how the FCC drew it up. There are some folks, tech providers, big ones, that are not putting a checkbox at all, but having when it's one to one only. So when the marketing is going out to one person and it's being submitted to one provider, that just the submit button with some language is acceptable without a checkbox. But I would say the most prominent is the single checkbox in the consent form.
Wow. All right.
What?
Just again, try and bring it around for agents where they might be on the street. And I
Right.
think I know the answer, but I'm going to ask it. I'm working an open house. Somebody comes in, maybe I'm using a sign-in sheet, maybe I'm using an iPad. There are all kinds of options, right? But they consent to give me their information. They willfully, one-on-one, I'm talking to them. There's no intent that it goes to anybody else or gets sold anywhere else. Am I okay? Or if I try to use any automation in the future with them, am I possibly putting myself at risk that they could turn me in, much like a do not call complaint?
It's prior written consent. So it's not verbal consent, it's written consent according to the law, right? And so you can imagine cases that this gets really tricky. I think an open house it's a really good point you make. I actually haven't heard many folks talk about open houses. It's a really good point. You are, when you sign the sheet, potentially giving consent, but you might want to put an extra little blurb there on the sign up sheet that says you consent to being, by signing the sheet, consent to being contacted, and you probably need to keep a record of that sign up sheet for the folks that sign up if you're going through the open house. So for open houses.
I'm sorry, Matthew. Does the
Yeah,
consumer need to be provided with a copy of the consent then?
We don't believe that you need to email them a consent or any of that kind of stuff. That them reading it and checking it off is fine. There are some other lawsuits. I don't want to confuse people, but because this gets really deep, but there are some other lawsuits going on right now that are like challenging, and it's just a lot of these brands who have been sued trying to like use legal maneuvering to get out of being sued. But there are some challenges to that, and that will be would require like a DocuSign process to get any lead. I don't think the industry thinks any of that stuff's going to go through. So I'm going to kind of set that aside. That is not happening with this law, just to be clear. But right now, Bobbi, there's no need to email them the documents or anything like that. So, but it needs to be written, which you can imagine, like if you just get a name passed to you from your loan officer friend or whatever, right, or business partner, and you say, hey, this person wants you to call them. Or if you meet someone on the street and you're like, hey, I want to call. This is where it gets particularly tricky because it's verbal, it's not written consent. And so could that person then sue you because you called them even though they gave you the name in person? Again, this is not like normal business activity, but this is like people trying to trick you in order to make a quick buck. So again, in a risk tolerance world, don't worry about that as much as I do the online leads. And, to some extent, I think, Tom, open houses are a good thing. Keep that sheet, maybe put an extra blurb on the sell sheet so that, and, on the page that they sign so that they can see it. But yeah, I personally don't worry about it as much as some people are about meeting people on the street and getting their name.
And when we talk about lawsuits, which is our favorite topic these days, who ultimately would be responsible should they violate and they don't have consent? Is it the agent? Is it the brokerage? Is it the portal? Whose responsibility is it?
Yes.
Great.
Yes.
Well answered.
So unfortunately, it's actually been litigated out already. There are agents at brokerages, many hundreds of agents, thousands probably now, that had been sued for a predecessor of this law that was not as tight. And there's liability at the agent level. There's liability at potentially the team level. There's liability at the marketing stack. There have been like marketing agencies and agencies of agencies that have been sued, that have been included in lawsuits. And then the brokerages are certainly have exposure to this for the actions of their agents. So we have brokerages and teams, for instance, that are starting to, and insurance is actually out ahead of real estate on this, but we have partners that are starting to lock it down. So you can't go buy from anyone you want, buy leads from anyone you want. You can't go as an agent, I'm going to prohibit you or prevent you in our terms and conditions of working. You can't go generate your own leads by running Google or Facebook ads or whatever. You have to do it in a controlled way that I've prescribed to you. And that's either through a tool I provide to you, through the CRM that provides that I've vetted, that provides the technology, or it's through a lead supplier. Again, you've mentioned a number of the portal names. I won't, because lots of them are my clients, but for a lead supplier that provides the leads to make sure that they're doing it in the right way. And so some of the largest brokerages are actually going out and kind of auditing and creating a list of folks that are allowed to sell leads, or you're allowed to buy leads or generate them through those mechanisms, because they kind of already checked them, because they have liability, right? And then liability, if I think about these automated calls, like you get into hundreds or thousands or of automated calls, and there's a class action, you have $500 to $2,000 per call or per text. And imagine you've called or texted a number multiple times, right? These things add up really, really fast to tens of millions of dollars.
Yeah. Yeah.
Wow.
We talk
Wow.
about the liability end of it. You look at the agents that have their own websites. What recommendations do you have? Like beyond the brokerage, they have their own individual websites. What recommendations do you have for those agents that aren't using the brokerage websites?
You need a disclosure form on your own website, right? So even if it's a one-to-one lead, again, we put in these kind of portal marketing systems for each individual brokerage for all their agents to use and do compliant marketing. It's one-to-one marketing, but we have a lead disclosure form opt-in on everything, regardless of where we generate the lead, whether we're spinning up automatically a listing website for you, or whether we're doing this, capturing a lead in Facebook or in Google. We have a disclosure form associated with that lead before we capture it, before we store the lead information, a disclosure form that the consumer checks. And you need to do the same. So wherever you're capturing a lead, your website, you're doing marketing, you have to have a disclosure form. If you want to see some language, there's a great website. You can, by the way, follow Evocalize.com. We have a blog. We're very active on LinkedIn. Follow us. We're talking about this stuff all the time, just trying to educate the market on it. Lawsuits are bad for everyone, right? And so, except for the attorneys who make lots of money. So, and then there's another series of websites I'll point you to. There's a website called TCPA-World.com, run by the law firm Troutman Amin. We've done lots of webinars with Eric Troutman and Pooja Amin, who are the two managing directors, like really, really well thought out. They put a lot of free material. They have some like free disclosure forums and stuff like that. They have a group called REACH, REACH, that's like responsible, ethical lead generation. I forget the acronym exactly, but on there where you can go get some resources as well. So I would just encourage you to go get some free resources where you can, because the attorneys, talk with your attorney. I'm not discouraging you from that, but they get expensive, right? Pretty fast. So, there's some free avenues for you to get more information about it.
Oh, those
Be
are
armed
great.
with good questions.
Yeah.
And we'll get those from you, and we'll make sure those are actually attached to this recording so that everyone out there can enjoy diving into that.
Sorry. Yeah.
But we do appreciate those free resources, because it's helpful at least to have a starting point and a guide in a basic understanding. This is so helpful, Matthew, for you to break it down for us. I understand it's such a complicated issue, and for you to break it down to us in kindergarten terms, we really do appreciate it, because it helps us to understand the seriousness of it.
Sure thing. I'm happy to. Again, like the worst thing for all of us, we've been through so much chaos with we're very deep in the real estate, and mortgage space, and the Sitzer, all the commission lawsuits. It's been chaos. And so you have market conditions, and you have that, and you have interest rates, and it's just yet another thing, unfortunately, and it potentially could be the biggest of all. So we're just trying to, not enough people know about it yet. So we're just trying to get out in front of folks. And then Tom, you've asked me previously about the April. I don't know if you guys want to talk about the revocation of consent stuff coming in April, if that's too much to throw at people at once, but I'm happy to just give a 30-second on that if people hear
I
about
was
that
just
thing.
going to ask if there was something we missed asking you about, because I'm going to try as best as I can to maybe ask you, okay, here's what I boiled down for a few best practices before we wrap this up. But
That's awesome.
what can you tell us about April? Because as soon as they hit those websites, they're going to see the April date too and go, okay, what's this?
I know. Well, so this is all about gaining. January is all about gaining consent, right? It's all about like, okay, getting consent. April, again, this is not focused on the house. These laws are not focused on housing alone, right? They're just general, like the consumer related, business to consumer related interaction laws related to the telephone. Okay. April, there's a kind of new law going into effect related to the TCPA that's it does a number of things, but the biggest thing it does is enforces revocation of consent. So removing consent from what we just talked about, granting consent, right? So you've kind of always thought that, you know, you get a lead, you have a lead, you market the lead, you give the consumer some pathways like an unsubscribe, right, to be able to get out of the lead flow. If they don't go through the pathways that you've described, like they don't check the box to unsubscribe, you're okay, right? Because they haven't done what I told them to do to unsubscribe. The problem is that not everyone has given easy pathways to cancel products and services or unsubscribe from these texts and communication. So the April deadline is all about giving the consumer a really broad berth in terms of opting out, in terms of revoking the consent that they previously given. And so these rules quite simply allow the consumer through any reasonable action to opt out, to be able to opt out, and for the provider of the communication, so you, to remove them from the list and stop messaging them within 10 days.
What's
So
reasonable?
this is an interesting thing. So
The court will tell you.
carrier pigeon, like dropping a package, on your front step. We don't know, but we do know that it's not the pathway that you've engineered only. And we also are a little bit worried, and the industry's a little bit worried about an entire enterprise. Because remember, if you're in a brokerage environment, the consent is given to the enterprise, not just to you, right? And so you are considered a salesperson according to the TCPA of the enterprise. So of brokerage. I hate to use any of them because they're all our customers. So I'm not going to use any of the big broker names.
That's
so
good.
Forgive me. But if you're kind of to the TCPA acting on their behalf when you get consent. And so the challenge with this particular revocation of consent via any means is the consumer could message you and say, remove me. They could message the brokerage and say, remove me. They could message another agent and say, remove me. And the rule applies to everyone underneath that service provider. So this is like, imagine a network of 100,000 agents right underneath one broker. And now you have to figure out like who's been removed and then remove them from being messaged within 10 days. It's just that's why people, Tom, to your question the other day, like that's like why people are nervous about that date. And it applies to everyone. That it applies to us as a software company for people like dealing with our software, right? We have to remove them within 10 days. Easier for us because we're centralized. When you're distributed like a real estate organization, it becomes much more difficult to manage the kind of removal of folks from lists like that.
Sounds like you understand independent contractors.
We've had to learn. Yeah. We've
Get them all to do the same thing. Holy smokes.
Totally.
Well, yeah, I can't thank you enough for all your time. And you have succeeded in scaring the pants nearly off of us.
Sorry. Maybe that's part of the purpose.
At least if people get out there and get educated. Again, we're not here to give legal advice, but if I were to try and boil all this down in my head, a couple of key components, really, I'd be looking to people to say, hey, quit using your auto dialer ever. if you've got action plans that are texting people, pull that layer off for now until we can figure it out. And from what I was hearing about, policy is coming to mind to me as a broker or brokerage. I better have something in my policy manual instructing people how to do this, and I can even think of some teams that seem to have their own internal policy manual for their team. You mentioned teams are in that stream of liability. Probably a really good idea for them to consult with attorney, figure out what you need to do in there. And then lastly, one we didn't hit on hard, but if the consent is with the brokerage and I'm an agent who wants to move brokerages 6 months from now, all of my efforts to get consent may be for naught.
It's really smart.
If I'm hearing this right.
Yeah, no one talks about that. So I was just talking with the mortgage industry group the other day about that, because loan officers move lenders too.
Mhm.
And so it's a couple interesting things about this. You're 100% right. And we're used to being portable with our own database, right? In the real estate space. And the consent in this world, the service provider is the representative brokerage. So if you've consented for your brokerage and then you take your database and you move to a new brokerage, you don't have consent to use automated technology to contact the people you are contacting at your old brokerage anymore. That consent belongs to the old brokerage because it's tied to the service provider, right?
Yeah.
And so this battle that we fought in this industry for years and years of like, it's my data, it's, whose data is it?
Yep.
To the TCPA, for this purpose at least, that data is consented to specifically to the service provider, or service providers, if you have multiple checkboxes, that you've generated the lead from, right? And so yes, this is a big thing. And then I would take this one step further and say, not only then do you have concern as the agent moving your database and the liability associated with that, but your new lender, I'm still in words, your new brokerage has concern, because if now you've brought your database, which we want you to do, right, as a real estate brokerage, but you brought your database and now you do something wrong, you're messaging them. Now I might be liable because you're messaging them talking about me, right? And you're representing me, but you're consented to the last brokerage, right? And so I might now have liability for you moving your database across. So it's a really nested mess. I'm glad you brought that up.
I'm back to dial the phone yourself. Type a text with your fingers until we can get this figured out, because this is a really short time frame. I can't believe how little I've heard in the industry about this.
Yeah.
With this coming, what are we now? We're recording this on the 10th. Yeah. So we're basically 2 weeks out. This is crazy.
Yeah.
A couple weeks out. So that's the biggest thing that we want to bring to our members, is that awareness, to try to keep people out of trouble and to give them the information that they need. I love these resources that you shared, Matthew, because it will help them to get a start to, not only talking about it here, which your knowledge is so valuable. So that's great. But then adding these resources to it it gives them more power in making the decisions and the adjustments that they need to do to not get sued.
Yeah, no, it's great. And we can add to the library that you distribute. We've built for those who are into talking with GPTs in AI chatbots. We built a chatbot in OpenAI's GPT store. We've loaded it with all the regulations, all hundreds of hours of podcast commentary, so you can go in and ask it questions just like you would. It's not your attorney either, and my attorneys have made sure it tells you that every exchange it has with you, but we'll put the link in for you too if that's helpful. Again, no one's tracking, well, OpenAI might be, but we're not tracking you on that. We have no visibility of who's doing it or who's using it or what. It might be a ghost town and no one's using it, but we wanted to publish it in case folks just wanted to continue the conversation and get more educated on their own pace. It's a pretty good resource if you're familiar with the OpenAI kind of GPT landscape.
That's awesome. Wonderful. And just a reminder to anyone that happens to watch this after the 27th, adjust fast, because it's not too late, hopefully, but just make those adjustments. If you're watching this on January 30th and go, okay, shut your automation off and pick up the phone and dial until you can make the appropriate adjustments.
Yeah. And make sure you have one-to-one consent proof on every lead that you get. If, in my view, we've always preached like you should be generating these leads yourself, because you control your own destiny that way, and and you can kind of push up and push down volume, and no one's going to come in and say we're not serving your area anymore, right? You control, you do exactly what the portals do. You can do it yourself. Like, there's no magic there. They just happen to be really sophisticated with data and technology, right? So we always preach, do it yourself, right? But no matter what you're doing, you have to push your tech providers, your vendors, everyone you're dealing with, to have the consent form and have proof of consent. Because you may, even if you decide to turn off all your technology auto dialers today, probably going to be a race to put that back in, because it's actually, super helpful. That's why it's being used. And so you don't want to, you want to start to actually get the consent. And I would argue leads that come without documented consent, far less valuable to you than leads that come with consent. So I would also think about that when you're generating or buying leads.
Awesome. Well, Matt, we've taken up a ton of your very valuable time. We can't thank you enough for what you're doing for the industry as a whole out there, trying to scream to the sky, and help us all understand that there's a heck of a lot more on the horizon than what just hit us back in August, and we got to stay vigilant that changes are coming. So thank you for everything. Really appreciate it. And I have a feeling, we're newer to this podcast idea. I have a feeling we're going to be looking to you for a little bit of an update in a few months to say, okay, all that stuff we thought would maybe work out, has anything new updated or changed? Because this is going to be a quickly moving target, I think, for compliance. So thanks so much.
You're right.
Matthew,
You're welcome.
thank
Thanks
you.
for having me on, y'all.
Thank you.